All right, folks, thank you so much for waiting so patiently. We are going to begin here at 2 minutes after the hour. So just to allow for a few more people to be able to join the webinar. And again, thank you so much for joining us today and spending your lunch hour with us. We're going to be going over different wealth strategies and estate planning for your trust and your final will. So definitely stay tuned. If you do have to drop off for any reason during the call, this will be recorded and available for you later on today. So you can definitely watch it on demand if in case you do need to drop off. We will be having a Q&A session towards the end of the webinar here. However, if you do have questions at any time during the webinar, please utilize the chat bar at the bottom of the screen. Well, at least for me, it's at the bottom of the screen. And type in your message. If you don't want it to be viewed by everyone, you can send a private message over to me, Melinda Cardona. And during the presentation, John will not be able to view the chat bar because he will be presenting. So definitely please either send any questions or messages that you have directly over to me personally, or you can send it as a group chat to everyone as long as you understand that everyone will see your question. And just once again, thank you so much for joining us today. We're going to be beginning in just 1 more minute just to allow some more folks to be able to show up. We did have close to 60 folks register for this webinar today. So I want to make sure that we allow another minute or so for folks to be able to join. And then we're going to go ahead and get started. All right, folks, so it is 2 after the hour, so we are going to go ahead and get started today. Again, welcome. We are so glad to have you all here today. Myself and Mr. John Fraker are going to be hosting this webinar today, and we're going to be going over wills, trust, just kind of all the estate planning and things that you're really kind of interested in learning more about. So again, thank you so much for joining. We are going to go ahead and get started. And just as a gentle reminder, this session will be recorded. So just know that if you have to drop off early, or if you're experiencing any kind of internet issues or bandwidth issues like we all are at this point in time, just know that you can always come back and re-watch this same session at a later time. So again, this will be available on demand. If you do have any questions throughout the webinar, please do take the time to type them into the chat bar. If you are comfortable, you can send it as a question to everyone so everyone can see it. But if you don't feel comfortable with everybody seeing it, I do encourage you to send over a question to me privately. Mr. Fraker will not be able to see the questions during the presentation because he'll be presenting. So if you do send me over any of the questions that you have, I will read them aloud if it's applicable to that particular slide. Otherwise, I'll wait for the Q&A portion towards the end. And once again, just thank you so much for joining us. So we're going to be talking about building and preserving wealth through your estate planning and your trust and your final will. And so I am Melinda Cardona with the Telco Credit Union. I'll be your moderator today. And our featured subject matter expert presenter is going to be Mr. John Eric Fraker. He is an attorney at law through his own firm, Ainer and Fraker. And so we're going to go ahead and get started. John, can you switch the slide for me, please?
Absolutely.
All right, so just to give you just a tiny bit of background on who I am in case you haven't seen me before. on campus. My name is Melinda Cardona, and I am actually the relationship manager for the Cal State University. So you may see me on campus, or you may see me during other financial fitness webinars. We have done a ton of different webinars for Cal State East Bay, San Francisco State, Sonoma State, and also San Jose State. And everything from home buying all the way through to retirement, investing, just understanding how to financially survive this pandemic. I know a lot of folks have been really kind of faced with a lot of adversity. So definitely feel free to come to any of our webinars that we have. We promise to make them as informational as possible. And we do have all the recordings available as well. So if you don't want to join a future one, but you want to watch a previous one, you can always do so, and I'll have all those links available for you as well. And up next, Mr. Fraker is going to introduce himself. And so I will be on mute, but just remember, you can always send through any questions privately to me or in the group chat to everyone as well. Thank you.
Thank you, Melinda. Can everyone hear me all right? Sound quality good? Excellent. All righty. So let's talk a little bit about estate planning today, wills and trusts. So here's a little bit on my bio. I'm a local product here to the Bay Area, born and raised in the South Bay. Did my undergrad at Berkeley, University of California, Berkeley, class of 95. Law school at USC Law School, 98. And I have a master's in tax law all the way back in 2007. So what I tell clients, the most important thing to know about my background and also my business partner, Leon Ainer, is that before we set up our law firm all the way back in 2002, we were both trust officers at banks. So before we ever drafted our first living trust, we had administered thousands of them for families throughout the Bay Area and Northern California. And why that matters, there's a lot about estate planning we're going to cover today, that where something sounds good in theory, but in real life, when dealing with real people, is not a good idea at all. So I'm going to give you the best of our wisdom of 20 years of doing this, and how your family can pass wealth successfully to the next generation and minimize family friction or fights over money. So let's go to the next slide. Start off all my presentations by saying a little bit of trivia. When do I need my estate plan? And the answer is not until the day before you die. However, unless you have a crystal ball or a magic 8-ball, you need to put your plan in place today. And the reason for that, national statistics are roughly 70% of Americans die without a valid will or trust. But I always say that about 100% of Americans intended to get around to it before they died, but it's just one of those things that people think about, and then they don't want to think about it anymore. They'd rather do other stuff than think about wills and trusts, so they put it off, and something happens, life intervenes. So we want to make sure that you guys get away from procrastination and put together a plan for you. So what happens if I die without an estate plan? Probate is the legal system in California. Probate means to prove the will, and intestacy, which is a big stinking mess. And we'll talk a little bit about that and how to stay out of the court system with your family. So if I can convey only one item to you today that you would remember and take away from this presentation, this is it. Everybody has an estate plan. So I have people come to our office and they sit down and say, I don't have an estate plan, but I'd like to get one. That's actually not true. Every single person in the state of California has an estate plan. You either have the one that you've created with your will and trust and other documents that reflects your values and your needs and what's right for your family, or you have a plan that the state of California and the probate code have created for you for everybody else, the default plan that reflects the needs of the state of California. So since most clients obviously don't want this, I just want to let you know, if you have a will drafted by the state of California, which is what we call the intestate code, this is what you're representing. Number one, I desire to pay the maximum amount of taxes possible. Two, I believe in letting the state choose the guardian for my minor children. Number three, I believe that the state of California would do a better job than I can in deciding who gets my stuff. And number four, I prefer to let the state of California choose the executor or personal representative of my estate. Now, obviously, no client has ever showed up in my office wanting to do these things. It's not what's important to you, but this is exactly what your estate plan says today, unless you have a trust or a will that gets you away from California's default. So the probate system, again, is the court supervised process of distributing estates to the next generation. at the highest level, I describe probate very similar in California to bankruptcy. And what that means is, like when you go bankrupt, all of your creditors line up and get paid, and then the unsecured creditors get whatever's left over at the end. That's pretty much what probate is in California. It not only is a process for transferring wealth to your kids, it's a process for identifying and making sure all of your creditors get paid. And in many cases, the creditors will wind up taking priority over the family. So the disadvantages of probate: it's an extremely expensive process. We'll talk about the breakdown and how we arrive at these numbers on later slides. But on a $1 million estate, which includes real estate, you're looking at least $23,000 to probate it. It's a very public process. It's time consuming and slow. Obviously, like with all things in the state of California, because of COVID, the courts are under a huge barrage from both sides. One is there was a whole bunch of cases that were shut down March and April, and all those cases got continued to later in the year. So you got more cases. And unfortunately, a lot of the state budget has been balanced by reducing court staff. So they're working more cases in fewer hours. And it's not fair to the court staff, but it's the world that we live in. So when you look at how long it takes for an estate to get through probate, you're really looking not just 9 to 18 months on average, you're looking closer to a year, even for fairly straightforward estates. And that's because the system is a court-controlled, court-supervised process with tons of delays. It's extremely inefficient, and it puts an overemphasis on formalities and really doesn't put an emphasis on families. By contrast, having a living trust and funding it, you will have the opportunity to keep your costs down anywhere from 0.5% to 1% to administer a living trust after somebody's died. The only people who can see your documents are the ones who are named in it. It's not a public record like the probate system. It's a far faster process. You can complete it in as few as 6 to 9 months on average. And it's a much more streamlined control system that really is, putting families first and putting substance and what's important to families ahead of everyone else. So let's move to the next slide. So a living trust is the foundation of your estate plan. It's what we call a revocable living trust. So a living trust has some tremendous benefits. Number one, you can revoke or modify it during your lifetime, right? So one of the things we always tell people is a living trust is a snapshot of your life when you create it. But it's not something that's meant to be never touched again or never updated as your family changes, as things change. And we'll talk about that, especially when we get to guardianship and other things, guardianship of minor children. We'll talk about why you might want to update your documents as your family evolves. Another huge benefit of a living trust is it provides for management of your assets during incapacity. So unlike a will, a living trust gives your successor trustee the ability to help you out financially if you are incapacitated due to illness or infirmity. So we have clients, obviously, who move to retirement homes, elderly clients who wind up with dementia or Alzheimer's and are no longer able to take care of their financial or other legal affairs. A living trust gives their children or their chosen trustees the complete ability to manage that for their benefit while they're still alive, without having to go and get a conservatorship from the courts. I'm going to skip over estate tax benefits. It's not a huge concern right now because of the estate tax credits are so large. It gives you, the person who sets up a living trust, complete control over how the money is distributed to your children or beneficiaries. And we'll talk a lot about asset protection features, which you can provide for your kids from a living trust. So again, if most people don't have a living trust or don't have a will, the default age that a child can inherit is age 18, right? So we like to think that it's a tough decision for a child at age 18 who's come into a couple $1,000s or hundreds of thousands of dollars. We think it's difficult and that they're going to wring their hands and decide, hey, do I want to go over here on the left and graduate college, study hard and do all that? Or do I want to buy a car, spend time partying with my friends, and then blow through the money? They've actually done national statistics that show that this is not a tough decision at all. Kids will almost always go for the plan on the right. And they've even done studies in all 50 states that say, what's the average age that a child is bankrupt or has spent through their inheritance if they receive it at 18? And the answer is usually around age 21 or 22, they spent all their inheritance. So the living trust gives you the benefit of pushing that back by giving you, the parents, control over how the money is distributed to your children. So again, the default is a child cannot inherit until they're age 18. But if you don't have a trust or other system in place, they're going to receive all their money at age 18. With a living trust, you can either distribute it to them when they're older, say at 25 or 30, or you can do what a lot of clients do, distribute, say, a third of their estate at 25, 30, and 35 when they're older and more responsible. So mandatory income from the trust in the meantime would begin when they're 18. So they're going to be getting some income from the trust that you've left them, and they're going to have access to all of the trust principal for anything healthcare related, anything education related. So all tuition, room, books, board, all the important stuff for education, and that's really broadly defined education, all paid by their trust. Maintenance and support, those are legal terms that basically mean necessities of life, food, clothing, and shelter, etc. So the reason that you might want to consider leaving it to your kids at a later stage is that they have use of the money that you've left them for all the necessities of life, and then they can receive the lion's share of their inheritance when they're older. And the bottom line is extremely important. Spendthrift provisions protect the money that's not yet gone out to them. So your living trust is a container for your assets. That's one way of looking at it. So step one, create the container, your living trust. And then step two is this very critical step here, which is called funding. So transferring your assets, real estate, stocks, bonds, mutual funds to your trust for the benefit of your intended children, your intended beneficiaries, your family, charities, the people that you want to get the money, your unintended beneficiaries of your trust, right? Your future ex-son-in-law. Perhaps you have a child in a bad relationship and you want to make sure they don't lose it, not to mention all sorts of creditors, predators, divorce, people trying to separate your family from their money. There's a lot of them out there. Spendthrift trust provisions are the provisions in your trust that allow you to protect your kids' inheritance. And the general rule is that while the property that, once you and your spouse have passed on, while the money remains in trust and has not been distributed to your kids, the inheritance that you leave them is protected from creditors. They cannot get at assets. They can't force distributions. Your children, and the reason for that is that your children do not own or control the trust assets. They have all the full use of the assets for the things that we've talked about, necessities of life. But we always include accumulation provisions that say, if your child's going through a lawsuit or a divorce, the trustee is going to turn off the distribution of the trust to them, which promotes settlement of legal claims against your kid. So that's one of the most cost-effective ways of providing asset protection to your children, is just simply leaving their inheritance in trust until they're older. And again, these provisions can be fine-tuned. Obviously, not all children are the same. Not all of their relationships are the same, right? So we have some children, some of our clients' kids start businesses, are in a very risky field where litigation is rampant. You might want to give them more asset protection. You have other children who go into jobs that are lower risk from litigation, and then they might not need as much. So you can fine tune each of these provisions for each child. So the basic estate planning package, number one, we've talked a lot about the benefits of a living trust. Two is your pour over will that goes alongside the trust. We'll talk about that. Your advanced healthcare directive and your healthcare powers of attorney. Obviously, during COVID-19, these are extremely important documents to not only have filled out, but to have access to them. We'll talk about that in a little bit. A durable power of attorney for finance or property. If you are alive but incapacitated, you want to make sure somebody has the legal ability to sign for your name. So there's a host of things such as pensions, company benefits, employer benefits that they may not be able to put in the trust, that your power of attorney will give somebody the ability to help you out if you are alive but incapacitated. And then obviously the grant deed is how you transfer your ownership of your real estate into the trust. So let's talk a little bit. If you have children who are under the age of 18, we're going to talk about the criteria for choosing a guardian for them. So it's legally required if you have a child under the age of 18 and the biological parents are deceased, it's legally required that you have a guardian to raise them until they're at least age 18. So again, as we mentioned before, if you don't put this into writing, you're going to have the judge make the decision for who the guardian is, and they're not going to they're not equipped the same way that you are to put the right people in place. They're just too overwhelmed to make a fully informed decision. So you want to choose somebody who's financially and emotionally stable, who's committed to the welfare of your children, who's absolutely able to work with the trustee and the other financial professionals, who shares the values that's important to you. I always tell people, they say, well, I'm trying to choose between, for instance, my brother and my sister. My brother's an attorney, but he's not necessarily great with kids. My sister's great with kids, but she doesn't have professional experience. I always tell people it's more important to choose somebody who's good with your kids. It's far easier to find somebody to manage the money on the professional side, like a professional trustee. It's much harder it's much easier to do that than it is to find somebody who's going to be good raising your kids. So really, obviously you don't want to choose somebody who has, drug or other problems, or would spend the money unlawfully, but they don't need to be MBAs or financial wizards. They need to be good with your kids. And then the part I put in red, extremely important. You want to discuss this with your intended guardians early and often. The last thing you want is for somebody to find out that they were named the guardian of your kids after you've died. So have that discussion early. Don't let there be any surprises. So moving on to your healthcare directive. This is a document like the rest that's drafted while you were alive in good health and sound mind, but it's executed during incapacity when you're not able to be there to talk to a hospital about what's going to happen. You are the one who are stating your wishes on life-sustaining treatment, but your agent is carrying out your wishes. And I emphasize these are all about your wishes, not somebody who's going to put in or substitute their own wishes about this. They're carrying out what you have put in your document. And again, the default for California is that if there's not something in writing, life support's not going to be withdrawn without a lengthy court involvement. One note I will give you for obviously during COVID times, we had a client of our law firm all the way back in March where both of the parents were diagnosed with COVID. One of the spouses passed away and the other went to the hospital. And the kids who were their agents called us and said, hey, we can't access their trust documents because, they kept them in their house and the health department won't even let us go in the house to get the documents. So we can talk about, there are different companies that you can use where you keep your health documents on file. And then they send you a little card like a donor wallet card. And then if you go to the hospital and you're not able to access your healthcare documents, they can just call that number and they'll fax it right over to the hospital. That's extremely important right now, is to make sure not only that you have these documents filled out, but in an emergency, you would have the availability of your documents. They'll be ready for you at that time. Your financial power of attorney, again, is durable. It survives your incapacity. It gives legal signing authority for your name to another person. It covers all aspects of your finances and property, whether or not it's in trust. So we put a huge emphasis on making sure that your trust is not only finalized, but that you fund it. You put all your assets into the trust. However, if you become incapacitated and we find out any assets did not make it in your trust while you're alive, the power of attorney is the document that's required. And unfortunately, we've had a couple situations where a family did not have a power of attorney and had no ability to put assets into the trust when their parents lost capacity. We're going to talk right now about a California specific issue, a Bay Area specific issue primarily. Anyone in Northern California who has purchased real estate, their house in the 60s, the 70s, the 1980s, and the 90s, who paid very little for their house, and now the house may be worth, $1 million or more. I have a lot of clients. We had one client which we'll talk about. They bought their house in Sunnyvale in the 60s for like $25,000 in Sunnyvale, right there in Silicon Valley, and another client who bought their house in Menlo Park for $50,000, also in the 60s. So obviously you're looking at clients who have a huge potential for paying taxes if they were to sell their house while they're alive. So capital gains is a tax that's based on the difference between what you pay for something and what you sell it for. And then you can add in some credits. Husband and wife who live in a property in California or anywhere in the nation for 2 of the last 5 years get a $500,000 credit against capital gains. And that takes care of, honestly, 95 to 98% of the country. But the people it does not take care of are right here in the Bay Area. So my client, for instance, who paid $50,000 for their house in Menlo Park, the fair market value when they sold it was over $3 million, and they wound up paying just under $1 million in tax to sell that house. So on the deed of your real estate, it's going to say how you and your spouse take title or how you hold title in your property. The California default for a married couple as a law is community property. However, we have seen over the years, the majority of our clients, husband and wife as a couple, come in owning their property in joint tenancy. For capital gains purposes, you absolutely want community property and not joint tenancy to be on your deed, and we can help you review your deed and make sure that that's done properly, and if changes need to be made, we can help you with that as well. Community property gives a full stepped up basis. So what that means is if husband and wife own a property as community property and one spouse dies, it eliminates 100% of the capital gains tax. If you own it as joint tenancy, it only eliminates half. So I'll give you an example of a family where how their deed was titled wound up making a 6-figure difference in their life. So the Sunnyvale client I was telling you about before, they bought their property in a good area of Sunnyvale in the 60s for $25,000. In 2007, they refinanced the property out of their living trust into joint tenancy and then put it back into their trust. So the last recorded deed for the IRS's purpose said joint tenancy. So when the father died in 2016, the fair market value of the house at that time was about $2 million. Had they owned it as community property, it would have eliminated all of the taxable gain. The daughter came to us and said, my father's passed away. My mother now is in a retirement home and she has no ability to ever return home. So she'll never go back to the house. We need to sell it. Could you run the numbers for us and see if we would pay any tax on that? Because they owned that property in joint tenancy, they were looking at about $100,000 possible tax. So all of that, because the way the deed is held, makes a big difference. So if you work with a firm like us or another law firm that does estate planning, you want to make sure that your real estate deeds, especially in Northern California, the Bay Area, you really want to make sure they're titled, your deeds are titled properly, and they continue to be titled properly during your life.
John?
Yes.
We did have one question that came in.
Yes.
It was on a couple slides back, and they just asked, what happens if an asset is not already listed or included in the trust? So maybe it was acquired after the trust was written, or something along those lines. Yep.
So again, we're going to talk about funding. And funding is just the process of making sure all your assets are in the container of your trust. If you die and those assets are outside of your trust, it's possible that those assets could go to probate. California, and California only, I'm not aware of any other state that offer this. California has a provision in our code that's been finalized and approved by the state Supreme Court. If you have an asset that is listed on your schedule of assets of your trust, like real estate, but the deed has not deeded it into the trust, if it appears on the schedule of assets, California allows a provision, it's called a Hegstead petition, which allows you to confirm that as an asset of the living trust, even after the person has died. So I had a client early on, all the way back in 2006, I believe it was, who called me after being discharged from the hospital. He had terrible failing health. I put together a trust same day for him, listed all his real estate. He had 6 real properties. We listed them all on the schedule of assets. He died before any of those deeds got recorded into the trust. So under California law, we were able to go to court, do what's called a Hegstead petition, and add those to the trust. So those assets did not go to probate. But it's extremely important to make sure that your trust is not only funded when you create it, but that you continue to bring assets that you acquire after that into the trust. So for real estate, you want to make sure that you have them deeded into the trust when you buy it. For checking, savings, and CDs, et cetera, you want to make sure those are owned by the trust. So funding is kind of an ongoing process. In the beginning, it's a lot of legwork to get stuff into the trust. But once that part is done, it's really downhill skiing at that point.
John, we do have another question that came through.
Yes.
What if both owners die? Will the trust be considered community if both owners are in California?
Can you hear me okay?
Yes, I can. Are you able to
Okay.
hear me okay?
Yeah, it froze up. It said my internet is a little shaky at the moment, so I just want to make sure you. So yeah, so as far as community property goes, that's how you hold title in the property. So the deed or other assets, it needs to reflect that they are community property. But what the specific example that I was using is only if one spouse dies. If both spouses have died, all capital gains are going to be eliminated. So what we're really talking about is a situation where one spouse has died, but the other has survived and wants to sell the property. You want to make sure that there's no taxes paid at that point. If both parents who own the property, husband and wife, have died, it will eliminate all of the capital gains are eliminated. There's a step-up basis at that point. Yeah. So
Along
that's
those lines, is the community property only for married couples, or what if they are domestic partners?
Yeah,
Or if
it's
they
it's
are
for all domestic partners in California. It's all community property. So yeah, you just want to make sure. That's honestly one of the things that we do for our clients who have assets that they need clarified. We have a lot of people who bought property when they were single and then get married or enter into a domestic partnership. It's always important to clarify assets going in, but as you go along, we can assist clients in preparing community property statements which say we want these assets to be held as community and these assets not to be. But yes, in California, it applies to all couples, married, domestic partners, you name it.
Okay, and then just real quick before you move on as well, there's been quite a few questions who have come in regarding this.
Sure.
Another question is, how do you get around capital gains taxes if, let's say, you're single
Right.
or there's just one owner on the property, on assets? What is the correct wording around that for California, and what really happens?
Yep.
Yeah.
So yeah, if you're an individual who owns real estate, the capital gains, it's in the Internal Revenue Code. It's called Section 121, and that's on this slide right there. That is the personal residence exemption from the IRS, the Internal Revenue Code. So if you have lived in the real property for 2 of the last 5 years, you qualify. If you're an individual, your capital gains credit is $250,000. If you are a couple, it's $500,000. And so capital gains is above and beyond that. So if you bought a property and you have more than, as an individual, and you have more than $250,000 in capital gains, it's not a matter of the trust, it's other tax planning that we can talk about. If you need to sell it during your lifetime, there's other stuff that you could do. But if you die, it wipes out all capital gains for you anyhow. So your children aren't going to have to pay capital gains tax.
Okay.
Right. So yeah, go ahead.
Oh, sorry.
No, go
the last question, which I don't know if it's going to derail what you were going to say, but the last question is, what if the property is within a partnership? And there's no real elaboration on that question. So I'm not sure if they mean like a domestic partnership or if they mean like maybe a small business partnership.
Yeah. So again, if it's in a domestic partnership, you can apply the community property terms to that. If it's a business partnership, all that has to do with the taxation of the corporate entity or the partnership entity and how that's done. As between a husband and wife or any other person, if you want property that's in a partnership to be treated as community property, then you would put that A on your schedule of assets as a community property asset, and you would also want to list that in a community property agreement and call that asset out specifically and say, even though it's in a partnership or an LLC or some other entity, we as a married couple, we deem this to be community property. So it's really the nice thing about it, I guess, is California and the state of California and the IRS will really defer to what you guys as a family intend, whether community property or some other way of holding it. But what we're trying to do is make sure that your documents are carrying out what you want to have happen. In other words, if you, as a married couple or as a partnership, if you define it as community property, you need to do that in a valid way so that the IRS will allow that and honor it. That's really, at a high level, that's all estate planning is doing, is making sure that your wishes, your intentions, what you want to have happen to your assets is actually what is legally carried out.
Perfect. Thank you.
Sure. Okay, I'm going to move on to a couple more slides. One of the sections people ask us on estate planning, how much is all this going to cost? So I'm going to go over some of your options for you. We call this estate planning finance explained. So these are some of the big options you have, right? So the big four categories: you have no plan, you have a trust mill that's run by not a law firm, including LegalZoom and stuff that you can pull off the internet. You have an attorney-run trust mill, so there are some attorneys out there who put their name on something that's mostly done by non-attorneys, but their name will be at the top, so it looks like a law firm, but it's more like LegalZoom or more like a document-driven service. And then you have the group of attorneys who do this for a living as their full-time profession. So with a no plan, obviously these are your do-it-yourselfers, the folks who meant to get around to it but didn't get around to it. So the upfront cost is free. Obviously, it doesn't cost anything. On the back end, you're looking at anywhere from 3 to 5% of the value of your estate goes to probate fees and costs, and potentially unlimited liability for your beneficiaries. Your non-attorney run trust mill, so your LegalZoom, We the People, your forms driven, you can spend anywhere $250 to $1,000. And again, if you ever notice in the fine print on LegalZoom, it always says, "We are not a law firm. You should have our documents and your family situation reviewed by attorneys." I would humbly suggest you just cut them out and go to a real attorney anyway. Somebody's going to talk to you about your situation. There's a huge industry right now of, the financial press and others who have spent millions, if not billions of dollars in marketing to emphasize that really estate planning is about documents and getting the documents done. It really isn't. It's really about your family first and foremost. And it's about making sure that your documents meet your family's needs. I've seen a lot of people who had a situation that even though the documents were fine because they had nothing to do with the family wound up in court spending tens of thousands of dollars to clean up that mess. And I'll give you some of those examples moving forward. And then an attorney-run trust mill, if you're really not sitting down with the attorney and you're just dealing with paralegals and you're not getting legal advice on your situation, it's basically a trust mill anyway. So again, the cost, much like it's reduced, but you're dealing with a situation where your family can pay a ton on the back end. And we'll go through that in greater detail and give you some examples. And then obviously you're dealing with a law firm, somebody with a tax expertise. California, everything is tax related. Obviously in California, capital gains, we just talked about that extensively. And so if you went to a document drafter and you didn't know about, for instance, the issue that we just talked about, community property versus joint tenancy, that's potentially in this area, potentially a six-figure mistake. So you want to work with people who do this for a living, who have litigated enough cases that they know what the courts are looking for and what the courts don't want to see. So it costs more upfront, but it saves you a ton of money on the back end. So let's give you some examples. All these examples are cases that our law firm was involved in. These are not hypotheticals, pulled out of a book. These are cases that we were involved in. So we talked about the statutory probate fee. This is set by the state legislature. It's in the probate code. It does not change from estate to estate. So if you die in any of the 58 counties of California, this is your probate fee. 4% on the first 100,000, 3% on the next 100,000, 2% on the next 800,000 up to 1 million. So you're looking at least $23,000 for the attorney statutory fee. If you have no will and you've not forced your executor to work for free, they're entitled to the same fee, the same 23,000. So that brings you up now to 47,000. You throw in some appraisal costs, filing fees, and so forth and so on. You're looking at anywhere from 3 to 5% of the value of your estate going to fees and costs. So here's a family. How hard can it be to do it yourself? As it turns out, pretty difficult. So this was a fairly, numerically speaking, a modest estate. By California standards, at least Northern California standards. It was about $500,000. The gentleman who passed away, his family friend, his buddy, helped him cut and paste a trust off the internet, printed something off the internet, did some cutting and pasting and drawing out and crossing lines and so forth. And he gave his personal property in equal shares. It said, I give my motorcycle in equal share to my 2 kids. I don't know how you do that. I don't know if you need a custody arrangement for the motorcycle. It's probably better than cutting it in half, but there's a whole bunch of stuff that makes no sense when you aren't working with a law firm. He had a cash only business that had to be sold after he died. He had highly contentious beneficiaries, the kind that would rather sue each other than the same room peacefully. And so at the end of the process, his attorney's fees were north of $15,000. His CPA fees were north of $40,000 to do a forensic accounting because his taxes and other stuff was a mess. So upfront costs, he didn't pay anything for an estate plan. On the back end, it cost the estate about $55,000 and about 1.5 years to settle out. The folks who mean to get around to it and don't, one of the larger intestacy cases, intestacy again means dying without a will or trust. A gentleman died owning 3 properties, San Francisco, Carmel, and San Mateo. It was a $6 million estate with no will, trust, and no first generation or no first line heirs. So kids, grandkids, parents, grandparents, that first generation was not there. So it took about 3 years of court cases, more than $100,000 in fees. The property wound up being split. $6 million was split between 24 beneficiaries, first, second, and third cousins. And every time I think about this case, I always wonder, why doesn't that happen to me? Like, why don't I have somebody that I'm third cousin to who's never met me and I wouldn't know me and leave me a couple $100,000? But that's what happened, right? And all the trust I've ever drafted in 20 years, I don't think I've had a single estate or trust that's left it to 24 beneficiaries. People really have a small number, relatively small number of people they want to leave it to. And obviously, not a lot of people are motivated to leave money to complete strangers. And that's what some of these third cousins were to the gentleman who died. We had another case. A gentleman had a $1.7 million estate, a house in Santa Cruz, some investments. He had a will, but he never got around to doing a trust. He left half. In the will, it said half to this charity and half to my remote cousins. Again, people he didn't really have much interaction with. That went on for more than a year. The total fees were north of $70,000. And the charity really got snippy with some of the family members and made everyone's life far more difficult as a beneficiary. And we talk to our clients a lot about philanthropy, huge proponents of giving money to charity, but there's a right way of doing it and a wrong way of doing it. And we go through that in detail with our clients. This case should honestly be taught in law school as a case study. What's the worst thing that could possibly happen? So this gentleman was extremely rich, very large estate, very complicated. But whoever did his taxes said, hey, don't spend a lot of money on an attorney. Just go over to Ye Old Trust Mill and fill something out that says what you want to have happen, and you're going to be fine. So he owned 28 properties, all of them in San Francisco Bay Area. He was on his second marriage, had children from his first marriage. So, his trust mill document said what he wanted to have happen: 4 properties to go to his wife and 24 properties to his kids and sister. Unfortunately, when he died, his second wife went over to the law firm to probate to administer his trust mill document, and they found that all 28 deeds on all 28 properties said joint tenancy with right of survivorship. That meant that 100% of the assets went to his wife, and 0 assets and 0 money went to his kids or his sister. So he unintentionally disinherited his children and sister when he meant them to have maybe 90% of the estate. All that to save some money on a law firm. 7 years of litigation is probably way more than that. We were only involved for the first couple of years, and then we swapped out for another law firm. Attorney's fees, I'm sure, were way north of $100,000. From my personal perspective, losing money is terrible, but the family is ripped apart. People who were, on speaking basis and friendly basis wound up no longer speaking, hiring lawyers and suing each other in court. So again, upfront cost maybe $500 to put this stuff together, and on the back end, that family paid through the nose, tens of thousands of dollars. So when somebody says don't spend a lot of money on an estate plan, the question is, do you want to spend a lot of money upfront, or do you want to spend it at the back end? Spending a little bit more today can save your family misery later.
And John, I do have a few questions that come in through the chat, if you don't mind me asking. So one question that came through It says, my mother had a living trust and she passed
Yes.
away.
Yes.
I'm a trustee and the executor, and also a trustee on the deed with property. I
Mhm.
didn't change the title, and I kept it after it was funded into a living trust. And is that okay as it's protected in the living trust?
Yeah, if the real property grant deed shows ownership in the trust, then it's part of the trust.
Okay. And
And it's kind of hard for me without seeing the documents to know if that's done properly, but we can definitely give advice of that offline when we're done today.
okay, thank you. And a couple more questions here.
Yes.
I have a person that said, we've been trying to figure out financial benefits and possibly disadvantages to getting married. We're both over the age of 60. If we get married, what do we have to do to protect our assets? I have a trust and a will that I created after I became a widow. We own our house together, and he has his own will. We
Yes.
leave our stuff to each other, and our house is now in joint tenancy, and it says we have no children.
Yeah. So again, I don't want to go into too many specifics of individual cases I don't want to practice law over this seminar, but I will say one thing to at least consider. The thing about joint tenancy that a lot of people are not aware of, the reason that it was used a lot in the 70s and 80s is it avoids probate, and it leaves it automatically to the surviving joint tenant. So if you have a situation where you want to leave something to the other joint tenant and nobody else, it's not a bad way of doing it. On the other hand, we have a lot of situations similar to what's been described, where husband and wife or a newly married couple have substantial separate property assets, and they want to leave it so that, if I die, my spouse can have the benefit of it, but when they die, I want it to go to my beneficiaries and not theirs. You want to make sure that that's done via trust or other documents. Joint tenancy is designed kind of to work once. In other words, you have two joint tenants, it works to get it to the surviving joint tenant, and then that's it. And then it's 100% that person's property. And so in the example that I gave before, the large estate, the reason that the kids were disinherited is because the real estate was held as joint tenants. Joint tenancy says everything that I own on my death goes to the surviving joint tenant. So when you own, for this individual, 28 properties as joint tenancy with your spouse, then on his death, 100% of the estate goes to the surviving joint tenant and is not going through probate, is not going to the trust. It goes directly to the surviving joint tenant. His name is removed, and all that property is now legally the property of the surviving joint tenant. So how that works out for families, joint tenancy is one of those things that's extremely powerful, and the vast majority of people don't know how it works in their situation. So that's why you want to work with a law firm and not go to a document drafter, because they can give you individual custom advice for your situation and not do a kind of a one size fits all cookie cutter.
And then also, what about people who are renters? They don't own any property, and their assets are basically just in retirement accounts and, personal bank accounts.
Right. So yeah, if you have under California law, if your estate is below a certain size, you can bypass probate through the small estate process. However, you still want to have powers of attorney during incapacity, and you may want to consider using either a will and or combo with powers of attorney to make sure that on your passing, they go to the right assets, or the assets go to the right people, without going through the court process. So we can talk about that. We have a lot of clients who are small estates who don't necessarily need a trust, but you still need the other documents. Primarily, as we talked about, if you were alive but in the hospital, if you don't have any documents whatsoever, the default is a conservatorship. So having at a minimum powers of attorney and a will is going to make sure that your family is protected. Even if you don't own real estate, even if your estate is below the small estate affidavit threshold, you want to make sure that all of the possibilities are covered through careful planning.
So along those same lines, another question had come through, and it said, if there's no will or trust and the estate value is roughly $50,000, does probate apply?
$50,000 is going to fit under the small estate affidavit or small estate petition. So probate, it's not a full probate process. It's an expedited process. Some bank accounts can be done just by forms. I will tell you that it's still better if you've specified either through power of attorney or a will who gets it. One of the things that people often forget is that they will fill out like an IRA beneficiary form or a beneficiary designation, and they'll fill it out and then forget what they've written on it, and 20 years will pass and they will have no idea who's getting it. So people believe that IRAs and 401ks, et cetera, never go to probate. That's not true at all. They go through all the time if there is a failure of beneficiary. So if I have an IRA and I leave it to somebody else and then I die, all the company is going to do is pull up the beneficiary designation form and write a check to that person. What happens if that person has died before you? It would go to the alternate. If you have no alternate, it goes to probate. So even in situations where probate is not the first line of defense or the first thing that's going to happen, you still want to make sure that you have a set plan for what happens if, for instance, I have $50,000 and it's going to go to my one son. If my son dies before me, what happens? And things like that. So you want to make sure, even if your state is eligible for the small estate process, you still want to talk to somebody and make sure all your other documents are lined up, and that you have a fallback plan, right? There's a whole bunch of estate planning where, how unlikely is it to happen? 1% likely to happen, 2% likely to happen. But I will tell you, when you go to the probate courts and you litigate and you sit there and watch all the other cases going around you, the courts are chock full of 1% and 2% unlikely to happen, but that's what happened.
And then I have just two more questions. I'm sorry,
Sure.
They're rolling in.
No, go ahead.
They're asking for just, a little bit more elaboration about the difference between an irrevocable and a revocable trust. And personally, I thought that an irrevocable trust meant that the person, the person who owned the estate originally, that they had passed on. And then just asking, what is the criteria that should be considered in figuring out which one is best, irrevocable or revocable?
Absolutely. So a living trust, which kind of what we're talking about is the foundation of your estate plan, is what's called a revocable trust. So the people that set it up, if it's an individual or a couple or whoever is the creator of that trust, they have the ability to revoke it or change it at any time. So for the basic bread and butter of estate planning, revocable trust is the way to go. Irrevocable trusts come up one of two ways. As Melinda mentioned, if one of you or both of you have died, then that trust becomes irrevocable, even though it started out that it could be changed, because the people who created it, who have the right to change it, if they have died, then with them goes the right to change the document. Then they become irrevocable after a death. The other side of the coin is there are a handful of different types of trusts that are irrevocable when you set them up today, but those are specific tax planning techniques, and you would not be using them for standard living trusts. So we have clients who do life insurance trusts. We have other clients who do charitable trust. All of those types are irrevocable from the moment they are established. That's why they work. But those are not for your bread and butter, moving the vast majority of your wealth to your kids. That's the role of the living trust, which is revocable. You want that to be able to be modified and changed as often as possible as your family changes. And also there's a big tax difference between assets that are in a living trust and assets that are in an irrevocable trust. And so if you own it in a living trust, there's no tax difference whatsoever. But if it's irrevocable, there is a different tax. You need a tax ID number. Irrevocable trusts are taxed differently, so capital gains, all that tax stuff is less advantageous. So the only reason to use irrevocable trust are for specific, charitable or insurance or other purposes. But just for your bread and butter, the foundation of your estate plan, a revocable living trust is where you want to be.
Okay, thank you. And then the last question I have in here for now is, can you designate someone in a will to administer funds to them, and they're a young adult that you don't trust to make, wise decisions? can they get the money over time? And I think you did go over this in the very, very beginning, but perhaps, they came a little bit late, so they may have
Sure.
not seen it.
Yeah.
Or if you do that in a will, does that absolutely require like a trust for tax purposes or other reasons, or, how does that work?
Yeah. So a will is only going to allow property to be distributed to a beneficiary at the end of the probate legal process. Anything beyond that says I distribute it in stages to a child at given ages under certain conditions that they clean up their life or so on and so forth, all that requires some version of a trust, right? So any of the strings attached to money that's left to somebody is going to need some kind of trust, property held in trust for the benefit of another. Otherwise, it's just their own property, and then the asset protection is gone. So you can do I'm not encouraging this at all. I've had a couple of cases where somebody had a trust that was built into their will. So they did not have a living trust while they were alive. When they died, the property went into trust for the benefit of the beneficiaries for similar reasons that you were talking about. The downside is that still has to go to probate. So you're not skipping the probate process to create that trust. Whereas if you set up a revocable living trust during your lifetime, you have all the same benefits, but you don't ever have to go through the court system. So you're saving your family, thousands of dollars and months, if not years, in the court system.
Gotcha. Thank you so much. I appreciate it. And you can get back to it now, and we'll wait for some more questions to come in.
Sure. So here's another example of somebody who thought they were saving a bunch of money up front that actually wound up paying through the nose on the backside. So I represented a lady. Her aunt died and left her $2 million in a trust. Seems easy, seems straightforward. The kind of stuff that you could do on your own with minimal help, or a trust mill. What she did was go to a trust mill that had an attorney's name on top, but didn't get a lot of specific advice to her family. The aunt changed her documents, her trust, 5 times in the last 8 years of her life. So every 15, 16 months or so, she was changing her trust beneficiaries. So people were gaining or losing, depending on whether or not they were added or removed, $500,000 to $1 million each time. When she died, the final trust that she had left her $800,000 house to a caregiver. That is a violation of California law. The probate code prohibits somebody who is a caregiver from receiving from an estate of the person they've taken care of, to avoid, obviously, fraud or undue influence. If you are going to do something like that and you do want to leave money out of your estate to a caregiver, the state of California, the probate codes, has a whole song and dance that you have to go through, a certificate of independent review, which means that you have to hire a second law firm, not the one drafting the document, but a second law firm, to advise you specifically on that one transfer and make sure that you understand pros and cons, and that you get a certificate of review from that independent law firm saying that it's okay to do that. If you do that, that's the only way that you would ever be able to do that. In this situation, none of that was handled properly. So when she died and the estate left, $800,000 in property to a caregiver, that violates the state law. That specific court case to get that asset back was done before I was brought in, and that case went on for about 1.5 years. And I believe that she had to settle out for more than $100,000 plus legal fees. When that case was settled, another lawsuit jumped in, and that was somebody who was a family, quote, nephew of the aunt, who thought that he should be a beneficiary. Remember, this lady changed her documents 5 different times over 8 years, and he said, hey, I was included as a beneficiary under the 3rd Amendment and then removed under the last 2 amendments. So he thought he could throw some money at it and see if he could shake some money out by suing my client and saying that all the other amendments were invalid except the one that included him for some money. He lost. At no point during the process did the courts side with him. He lost badly. On the other side, my client still had to pay money in legal fees, and she also had to pay some kind of settlement to get this guy to go away. It wasn't as bad as the first one. It actually wound up being about half as much money as my client initially offered, so she saved a ton of money. but it was all unnecessary. All of this could have been avoided by working with a law firm that stands behind their work. That's the primary difference between like a trust mill or even LegalZoom. There's no one to stand behind the work. If you download your living trust off the internet or you get it through a document prep company and one of these situations happens and your estate winds up in court, there's no one you can sue. There's no one you can talk to. Nobody's going to make things better for you. You're just going to have to suffer the consequences. Our humble advice, get your stuff done, your estate plan done right the first time. Spend the extra money up front to get it done right. Work with a law firm who knows what they're doing, who does this as their primary business. Somebody who's going to stand behind their work, as I mentioned. And as I always tell you, as I mentioned before, there are people spending literally billions of dollars in marketing through all the financial publications, Wall Street Journal, all the magazines, saying documents, 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 documents. And I'm telling you from 20 years of estate planning and litigation, it's more about the people than it is about the documents. You can have flawless documents that will be a disaster for the family if they have nothing to do with the people involved. So this is a relationship-driven industry. It is not a document-driven industry. What you've been marketed to, those messages are dead wrong. And the court system are chock full of people who thought, hey, it's just, we got the documents. The documents have nothing to do with their family. So today we're going to talk about, this is an exclusive offer if you are a Patelco member. It's a special offer that we're making to you. Our normal estate planning package, which is the living trust, the wills, powers of attorney, and deeds, is normally $2,500 as a fixed fee. That includes phone calls, emails, and so forth, everything necessary to get the stuff off the ground and going. We have a special discounted rate for Patelco members at $1,500, $1,500. That's my cell phone number if you would like to set up an initial consultation to see if this is something you need to spend time or money on. That's my phone. That's my cell phone number. You can call. The initial consultation is always free. And we also offer, because I'm a realtor with Keller Williams, we can give you a free home valuation if you would like, if you're a Patelco member. So it's $1,000 savings to work with us if you're a Patelco member. So membership does have its benefits. And I think Melinda wanted to talk a little bit more about other benefits of Patelco membership.
Yes, I do. And then I do have a couple more questions for you that came in as well. So I want to make sure that I real quickly just kind of tell you a little bit about some of the benefits of membership with Patelco. So in case you aren't already a member, which I know most of the folks on this call are already Patelco members. If you aren't already a member, just so you know, membership is free. You don't have to pay anything in order to join the credit union. There's no monthly or annual fees. And really, it's just a very simplistic account. And a great way for you to be able to save for, future, for rainy day, what have you. We basically have everything that a major financial institution would have. So if you're banking with Chase or B of A, we have all the same things. Really, the primary difference is because we are not for profit as a credit union. You will find that you gain more dividends on your deposits and that you pay significantly less in interest when it comes to your loans. And I even have a picture of the mobile app on there as well. So just in case you're wondering, how do I do my banking at a small mom and pop credit union? We're actually one of the nation's largest credit unions. And so we do have a very amazing app as well. So you don't have to worry, during these COVID times that you have to come into a branch to do your banking. You absolutely do not. And I have my email there on the screen. So if you do have questions, and again, I don't work on commission. So if you want to join, if you don't want to join, it doesn't matter to me. I will still get paid the same. But if you have questions regarding anything in finance, you could definitely consider me your friend in finance. You can reach out to me anytime, day or night, and I will be more than happy to answer any questions that you might have, especially if they're like concerning credit, maybe buying a home in the future or something like that. I would love to help you. And then just so that I can slide in some questions here. Okay, so one person did ask if I do sign up to be with Patelco, would I qualify for the discount package of $1,500? Yes. So again, it's another benefit there. And then also someone asked, how do I become a member? Do I just fill out an application? Yes, I can send you an application, or you can come into a branch. or you can call us through the 800 number. You can go online, however you feel most comfortable. Again, none of us work on commission, so it doesn't matter to us how you join. We would love to have you as a member. And again, even if you just have questions about general membership stuff, we're all happy to help you and give you some good advice on finance, anything finance related. And so then a couple more questions that came in. If you change the real estate title from yourself to a trust, does it change the real estate tax base like a sale?
It does not. So anytime you do a transfer of any type, of any titling or ownership, you fill out a preliminary change of ownership report. Under California law, and this is true in all 50 states, but in California law, there's a section that you check on the P Corp preliminary change of ownership report that says this is a transfer to a revocable trust. That is an exempt or disregarded transaction. So there's no triggering whatsoever of any real estate or any taxes, federal, state, or local, to a living trust. It is, in IRS parlance, it is a pass-through entity or disregarded entity. And that means that there's no change whatsoever. And we've even had people say, well, would that trigger my due on sale clause for my mortgage if I put it into a trust? The answer is absolutely not. There's actually a federal law called the Garn-St. Germain Act. And again, that's true in all 50 states, not just California. Putting your real estate into your living trust cannot trigger a due on sale clause or any tax reassessment. It's just about making sure that, when you do the deed, you want to attach the preliminary change of ownership report, and they check a box that says this is a transfer to a revocable trust, and there's no tax at all to that.
Okay, great. And I do have two more questions. Sure. So one is, can anyone join Patelco? So we are not necessarily open to the general public. However, if they are a family member, household member, anything like that of yours, they would automatically be eligible for membership through you, because you were an employee of Cal State East Bay. So don't worry if it doesn't look like they're able to be eligible to join online. You can either ping me separately offsides, and I will help you, and I'll get the app filled out, and I'll let a manager know that they're a family member or a friend of yours, and we'll make sure that they're eligible to join. So don't worry about that. Another question that came in is, could you give some good examples of leaving part of your estate to charity?
Yeah. Oh, I love this part. Yeah, there's a variety of ways that you can do that. I love philanthropy. I love talking about that with my clients. I don't get as many questions about it today as I did the first decade of my career, when the federal estate tax credits were low, and charitable planning is one of the best ways of addressing tax situations. So charitable planning, you can either use, like, for instance, a charitable remainder trust or a charitable lead trust. Some people who want to leave a lot of money can either leave through a family foundation or a donor advised fund. But if you're not going to do that, and you just want to leave a specific bequest to charity, what I encourage people to do is, the number one thing you don't want to do for ease of use, and also for ease for your family, you don't want to leave a percentage of your trust to a charity, because that makes them a co-equal beneficiary. Even if it's 1%, they become a co-equal beneficiary to every child, and can mess up the process and get involved in the process at a level that you really don't want them involved in. Especially because, when you're saying, I'm leaving you 5% of my estate, the question is 5% of what, right? And then if there's assets that are difficult to value, or that want to be handled in a neat and easy way, somebody who's a charity or outside the family, they might argue with you on the transfer of that asset, or even its valuation. So all the way back in the dark ages, when I worked as a trust officer in the 90s, how long ago does that seem? Pre 9/11 even. We had a case where the estate had already distributed all the assets, except for there's about $2,500 of what's called oil, gas, and mineral rights in Texas. And we had them independently appraised for about $2,500. And there are companies who go out of their way and say, hey, it may not be worth much to you, but we bundle them together. So we'll offer you, cash, $2,500 for that asset. And so the person who died left their estate half to their daughter and half to a charity. And the daughter said, sure, I'll just take, my half of the $2,500 and move on with my life. And the charity was like, nope, we want that asset in kind. And they were actually threatening to sue the estate over that. And they have the right to do that because they're a beneficiary. And so, the downside of that is that we had to go then. This is an asset that had been passed down 3 or 4 generations without proper chain of title. So because of this charity and their inability to be flexible, we had to go hire a law firm in Texas to reestablish 4 generations worth of transfers to demonstrate that, what they were getting was their actual, their legal property. So the estate wound up spending more than $2,500 on legal fees. And we've had that happen multiple times where a charity will fight a family over the valuation of an asset, right? Or let's say that you have 3 kids or 4 kids or whatever, and one kid wants to buy out the other beneficiaries to live in the house, right? I want the house. I'm happy to buy out my siblings. You're never going to get a charity or other third party to agree to a low valuation on that asset because they get less money. So one of the best ways, if you're not going to do, a big fancy charitable trust or foundation, one thing we encourage people to do, it's super easy, is if you have an IRA or you have a 401k, those assets to a child, they have to pay income taxes when they take the money out. So if you want to leave, let's say that you want to leave $50,000 to charity when you die, or roughly that amount, you can just leave the charity as the sole beneficiary of that one asset. It's not part of your trust. They're not an overall part of the estate, so they couldn't challenge anything else under the living trust. Just when you die, that $50,000 goes to the charity. They get the full benefit of that money without paying taxes because they're a nonprofit. And your kids wind up doing just fine, right? If you gave your kids that $50,000, they would not get all of it because they'd have to pay taxes on it. So your kids would actually be happy if you had to give an asset. You want to give an asset that's pre-tax, like an IRA or 401k, and that's super easy because those assets are not part of the trust unless you titled them that way. So one of the best ways to leave a good amount of money to charity, 20, 30, 50, $100,000, you can just leave them as the sole beneficiary of your IRA, and they will get, dollar for dollar, they'll get all of that without paying taxes, and your kids just go on with their life and get all the money from the trust. And that keeps everybody happy. Charity gets their money, kids get their money, everybody's separate, and everyone's happy.
Thank you. So I have several more questions. So first question is a Patelco question. Do you have branches on campus? So we actually, before the pandemic, pre-pandemic, we were doing on-site office hours, and that meant that we were actually in the student administration and I think faculty building. It was the FA building, and we were there once or twice a month for about 4 hours, being able to just kind of be a pseudo branch and be able to help people on campus. So because of the pandemic right now, there's a lot of staff and faculty that aren't even really allowed to be on campus for safety reasons and just being precautious. And so it's the same thing for Patelco. At this point, we are not on campus. And I don't know when exactly both Patelco and the Cal State universities have kind of put the kibosh on that for right now. So we hope to be back on campus soon. Unfortunately, because of the pandemic and the way things are going, I have no idea when I will get the authority from my CEO, and I don't know when we'll get the authority from, benefits or facilities or, the powers that be to allow us back on campus as well. We do have branches within about no more than a mile from campus. So we have one in Hayward that's like right as you're about to jump on the 92 to go west. And we also have another one in San Leandro. And both of those are really, really close to campus. So just in case you did need to come in person, they are really busy branches. So if you do want to come in person, I would definitely recommend reaching out to me so I can get you an appointment. So that way you don't have to wait, because I don't want you to have to sit in a branch or sit in a crowded waiting room or anything like that. So several more questions. I want to make sure I get one question, because this gal did ask me quite a while ago. If her family wants to come in and set up an appointment to speak with you about doing a living trust, do you have anyone in your office that is Spanish speaking that can help to translate and be able to walk them through the process?
We have outside advisors that we use for that. I think kind of the key distinction that we want to be careful on is if a client is bilingual and they would just prefer to have, Spanish translation for our discussions, but it's okay for them to have their documents in English. That would be something we could assist with. On the other hand, we have clients or family and say, this client is not bilingual. They would prefer everything, including their documents, to be in Spanish. I think it would be more in service to that client to send them to a law firm that can do that and is set up for that.
That's understandable, and I think they would respect that as well. So hopefully that answers that that particular question. So there is a couple more questions I want to make sure I ask. So what if you wanted your assets to go to your children but not your spouse? Ouch. Can that be structured in your living will?
Yeah. So the classic attorney's answer, it depends, right? So you can leave your interest to whoever you want, right? So if it's a community property asset, you can leave your community property and your separate property, your one half of the community property, to anyone you want. We've had that happen. It doesn't happen a lot. If it's not agreed by everybody, it's almost always a litigation matter later on. But the law does allow you, even if you are married, to leave your interest or your half the community property and or separate property to whoever you want and not your spouse. If it's something simple like cash, that can be accomplished, somewhat straightforwardly. If you have assets like a business, real estate, or other things, it's a lot more difficult to accomplish that. So I don't want to paint an overly simplistic picture that it's super easy to do that. It's not. The law allows it, but carrying it out is something that's you got to be extremely careful about that.
Okay. And then if your grant deed is joint tenants versus community property for me and my spouse, how do we go about changing that?
Yeah, so grant deeds can always be replaced by newer or superseded by newer grant deeds. So for instance, if you had a grant deed and it said husband and wife is joint tenants, we could help you prepare a deed putting that in a community property. And then if you have a living trust, a second deed putting it into your trust. And that way, the benefit of doing the 2-deed process is that you have a record with the county recorder's office that you intended it to be community property. But there's more than one way of handling it. Sometimes you do it by deed, and sometimes you just do a standalone community property agreement. And that all depends on the family and each individual situation. But there's more than one way of handling that.
Thank you. Okay, and then one more question. When executing a living trust, does it matter what kind of lawyer to assist with executing it?
Oh, good question. So I'm assuming by execution you're meaning administration. So after somebody's died, yeah, you want to use somebody who has experience doing it as their primary business, right? It's not enough that that they're a licensed attorney. You really want to focus on somebody, whether drafting or administering. You want somebody who has a lot of experience in doing that specific task, right? What I tell my clients, when you come to us and set up your living trust estate plan with us, it is not a legal requirement that you come back to us or your kids come back to us after you have died. The documents that we create stand on their own. There's nothing special or unique about our documents that ties you to our law firm. So your kids, if they have a better relationship with somebody else or they don't live nearby and they want to work elsewhere, our documents stand on their own, and they can be interpreted and implemented by any law firm that has a skill set in this area. But you don't want to go to an all-purpose law firm where 99% of what they do is employment law or personal injury, and then and they spend about 1% of their time on trust. You want somebody who's spent a good amount of time not only in drafting trusts but in doing the administration after somebody's died, implementing it, making sure the beneficiaries are on the same page. That's really something I can't stress enough. Um, a lot of estate planning is theoretical until it becomes irrevocable when somebody's died. In other words, if you have a bad living trust and you're still alive, nobody's going to know. Once you die and it's irrevocable and it's a mess, it's too late to fix it at that point. So really that's where you want to put your emphasis, is working with a law firm that has experience not only on drafting documents, but also on going to court, probate. Also somebody that has administered a lot of living trusts and sees how they operate. That's why in the very beginning of our presentation, when I introduce myself, I say the most important feature of my biography is not just my education, it's also the fact that both myself and my business partner as trust officers at banks have administered thousands of living trusts for families all throughout Northern California. It's a much deeper understanding. When you're setting up a trust, there's a lot of good stuff that sounds okay in theory, but once you understand how they operate when somebody's died and how family works together, there's a lot of stuff that's a train wreck if it's not being put together properly. There's a lot of stuff that sounds good, but in practice is not good.
And then there's another question here. So for setting up the trust, is it a flat fee? And then also, is there a charge for each time, one of the people in the trust changes the trust? And I know that
Yes.
Last time we did this, you were talking about how, it's good to take a look at them and review them every 10 years or so because of sale dating or something along those lines.
Sure.
Could you talk about that a little bit?
Absolutely. So yeah, updating your documents, we tell people you want to update them if your family changes, right? If you have more kids or grandkids, if your kids get married or divorced or any of that stuff. So if there's a substantial change to your family, you want to make sure that your documents reflect that. We talked about guardianship briefly in our presentation. That's one of the number one reasons people update their estate plan. They put together a trust and wills and set up their guardianship while their kids are small, 2-year-old, 3-year-old, and whatever. And they choose a guardian according to what's right for that kid at that life. And then they come back to us when their kids are in junior high or high school, and they would have a different situation or a different choice of guardian at that point, because a child who's 2 or 3 doesn't have family, friends, or situations that need to be, that they need to be in the same area, right? If you have a guardian, for instance, in another state, and you pass away and you have a 2 or 3-year-old, they're going to that other state. On the other hand, if you have a kid in high school who's a senior or a junior, and they're 1 or 2 years away from being 18 anyway, you might choose a different guardian to keep them in the same high school with their same friends and keep everything on the same path. So that's a classic example of why you want to update your estate plan to make sure that as your family changes, so does your trust. I had one lady who brought me her mom's will, said my mom died. Here's her will. And it was, I think it was 15 years old. And she'd never updated anything. And it included, her will included her ex-husband, and they had been divorced for a decade and left money to his kids, which were never her kids. It was a train wreck. And so, as I emphasize, your living trust and your estate plan is a snapshot of your life when you create it. If your life changes substantially or the law changes substantially, then you want to update it. So, you don't need to update it every year. I probably wouldn't wait 10 years to update it. There are some documents where you've been, discussing with other clients, like a financial power of attorney, where if 5 or 10 years have gone by and your power of attorney is 10 years old, some banks or other financial people will want to make sure that there's nothing newer or sooner or later that superseded it, taken over, because we live in a litigation society. Everyone sues everybody, right? So if you show up or your kids show up at a bank with a 10 or 15-year-old power of attorney, the bank's going to be squeamish because they want to make sure they don't give you the power of the account, and then somebody else a week later shows up with a newer power of attorney. Hey, that old one that you honored and gave people power over their money, that was already done away with. So it's not a case that the document stops working. It's that banks and other financial people become squeamish when they get old. So I would say at a minimum, you want to check in with your attorney every 1 to 2 years just to talk it out. We only charge money when we update the documents. So the fixed fee includes everything in the drafting of documents, phone calls, emails, everything necessary to get your plan going. The only thing our fixed fee does not cover are notary fees and recording deeds, because they all go to other parties. They don't come to us.
That makes sense. There's a few questions that came in that are actually almost identical, and they're all asking, you know, if we it's a two-part question. A, if we have an existing trust or will, can we bring that to you? Can you review it? Can you update it? And
Yes.
is that fee different than the fee that you kind of gave earlier, the $1,500 fee?
Sure.
And then the second half of that is there any cost for administering the trust? So what might the cost be
Yep.
later on, you know, down the line?
Yeah, absolutely. So two questions. Number one, our fee for reviewing is free, right? I'll review somebody else's documents and say if that's good. Number one thing I'm going to tell you though, as I've, hammered on this time and again, it's not just about the documents, it's about your family and whether the documents you have are right for your family and whether they accurately reflect your situation, right? So somebody says, hey, this is my dad's trust, is it any good? Like, I can glance at it, I can give it a quick skim, and maybe 10% of the time the trust is just garbage, and I'll tell you that. But 95% of what causes people problems in litigation is not because the document on its face is defective, it's because it was implemented wrong or it has nothing to do with your family. So going back to my earlier example, I'll roll the slides up. In this guy's case, who had 28 properties in San Francisco, his trust mill document said what he wanted to have happen. If somebody said, hey, is this trust mill document any good? On its face, it appeared to be good. The real problem that cost that family hundreds of thousands of dollars is that it was empty. It was an empty container. It had never been funded. He never got advice on funding. He never got advice on taxes. He never got advice on what happens if there's a conflict. He got no advice because he wasn't working with a law firm. So if somebody just said, hey, is this trust mill document any good? Maybe, but really what caused that family disaster was not that the document on its face was garbage. It's the fact that it had nothing to do with his life whatsoever.
Thank you.
And then the other question, sorry, the other question is, do we charge money to administer an estate when somebody's died? The answer is yes. How much that is depends on the amount of work. So if it's just a deed and some other stuff, it's actually really cheap. There are some things that every trust or estate have to do as legally required by law. But even that can be, a lot of that can be skimmed over if the beneficiaries all agree, or for instance, if you only have one kid, right? So, after somebody dies, every estate needs to have a valuation set on the assets, right? So you have to value the assets. You have to gather all the assets and make sure that they're all in the trust or they're passing appropriately. You got to do your taxes on the return. You got to do an accounting. A lot of that stuff can be handled informally if the beneficiaries agree, right? So if you have one child or one beneficiary, they don't need an accounting because they're the one in charge of the money. So you can save a ton of time and money in a situation like that. If you have 2 kids or 3 kids and they all get along wonderfully, you can save a ton of money there. What drives up the cost on administration is when there are conflicts between the beneficiaries or when the plan is set up in a old manner that doesn't really reflect your current family situation. That would be something where the cost could be a lot of money. So administration is really open-ended. There are some there's some tasks that every state has to do, but in a family situation where everybody gets along or where there's only one family, even that family can save a ton of money when everybody agrees or works together on that. But there's a lot of situations where that spirals out of control, where the kids are fighting each other and everybody gets their own law firm. So I can't really quote a fixed fee because those are just completely open-ended.
Understandable. So just a couple more questions. So
Sure.
if you can please share your contact information on the screen, because a couple of folks
scroll.
asked for that.
No.
And I
lost my screen share.
And I will send out an email to all the folks who did join today, and I will copy in on that, John. So
yep.
they will get your contact information, but just for them for right now, because I don't know if they have
Yeah.
to jump off the call.
Yep.
And then
There's my
one
info at the
other
bottom.
question, would a married couple each have their own trust, or do they have a joint trust? And I think it's a joint trust, but I'm going to defer to you on that.
Yeah, and that's a common question. It depends on the family, right? It depends on the marital situation, your estate assets. A couple that's been married to the same people their whole life, and didn't really have any assets when they got married, that's going to be a joint trust, easy. If it's a second marriage or it's a later in life marriage where one or both of the couple have substantial separate property, that's property that they brought into the marriage that they want handled differently, you might do separate trust for that. And then, certainly a situation where you're trying to figure out his, hers, and ours. For instance, one spouse says, when I die, it goes to my kids, but not his kids. Or when I die, my trust goes to him for his life and then back to my kids and vice versa. All that gets factored into whether or not one or two trusts are necessary or easy. We have some families that have a very complicated situation and they still only need one living trust because everybody works together to work it out and everyone trusts everybody. And so therefore one living trust can handle a wide amount of complexity, including blended families and so forth. And then there's other families where that's not the case, where people are not necessarily getting along that well. They may not be fighting, but there's not a huge level of trust. That family might benefit from having things ironed out in advance, and completely separate so that everybody has their own stuff and everybody knows irrevocably what happens.
All right, well, that's all I have for questions. So if anybody else has any other questions, you're more than welcome to type them into the chat bar now. And just as a reminder, this session is recorded, so it will be available to you at the conclusion of the event. So a couple hours from now, because it takes me a while to upload a file this large, but you'll be able to watch it on demand. So in case you had to leave early and then you came back, or you came late, don't fret. The information will still be available to you. And I will send out an email with both my contact number and email, as well as John's. So if you do have personal questions that you want to ask kind of offsides, again, I'm your friend in finance, and John definitely would love to work with you as well. So, do feel free that you can reach out at any time if you have any questions, and we'll be happy to help.
Melinda?
Yes.
Hi, it's Victoria. I just wanted to say thank you to you and to John for your time this afternoon. Thank you to all the employees who participated on the call today. And this was excellent information, and I'm sure we'll have further workshops coming up in the fall where we can address other topics as well. But for today, thank you so much for facilitating this conversation with us.
Of course, it's our pleasure. Thank you so much, Victoria. And one last question, John, before we jump off as well. Do you have, and I'm assuming this is going to be a yes, but do you have an organized sheet to follow to gather assets and gather the appraisals and things like that?
Yeah. So for our clients, we send out our estate planning questionnaire. Is 3 pages. And then we have an attachment page, a 4th page, that's for listing out real estate and other financial assets to go in your schedule of assets. But yeah, we have a very simple process. So I've worked over the years to cut it down to the very fewest amount of pages possible to not stress people out. So the answer is, yeah, we have a way of helping you figure that stuff out without scaring you to death.
Wonderful. Well, thank you very much. And there's a lot of gratitude coming in through the group chat. So everyone is
Awesome.
saying, thank you so much for the session. It's very helpful,
Sure.
Great webinar. So,
Sure.
so thank you. And if nothing else, I wish everyone a wonderful rest of their week. And thank you for your time today, because I do appreciate it.
Thank you.
Thank you. Thanks, Melinda.
Have a great rest of your day.
Bye-bye.
Thank you. Bye-bye.